To start, I'm delighted to introduce Ayelet Sela. Ayelet is an assistant professor at the Faculty of Law of Bar Ilan University and a researcher at Law Data Lab and the Data Science Institute. Ayelet's scholarship and teaching revolve around law and technology, dispute system, design, courts, and empirical legal studies. Her recent work on choice architecture, procedural design, and access to justice in courts, and online legal services is very important in the field. She also works on the application of machine learning methods to legal data for analytical purposes and in order to develop decision support tools and governance mechanism, themes which of course are central to the ACT project. I'm very happy to receive her online at our annual meeting. Ayelet has published recently a series of fascinating papers on ODR, court design, and nudging, papers that are raising very important questions about the ethics of online conflict solving, the art of manipulating people toward a specific outcome, a paternalistic approach to dispute, and the dangers of techno-solutionism, to speak like Evgeny Morozov. Ayelet, thank you for accepting our invitation. The online floor, if that's even possible, is yours. Thank you.
So, hi everyone. Thank you for having me. It's really a great honor and a pleasure to share some of my thoughts and some of my work with such a great group of scholars. I'm very intrigued by the work that you are doing at the ACT project and the Cyber Justice Lab generally. So I'm really looking forward to this interesting discussion, and I hope we will come up of this session with some interesting research ideas and possibly collaborations. So thank you again for this wonderful opportunity. So this is also a good opportunity to thank Maria Fernanda for initiating this invitation, and to Professor Ben-Kelly for inviting me. So thank you both personally. So the goal of my talk today is to introduce this idea that digital choice architecture matters in online courts, that the design of online courts should be informed by what we already know in this field, but that there are also specific considerations in digital choice architecture in the context of online courts that were not relevant in the context in which this body of knowledge has developed, which is in the UX, UI, information systems context, and particularly in business-oriented environments, in consumer-oriented environments, where the goals of choice architecture were different. And this issue is becoming particularly important in the wake of recent years' really rise in the launching of different online court initiatives, online courts and tribunals. I'm going to refer to them as just as online courts in this talk, but there are really a combination of ODR, online dispute resolution processes that are hosted or launched by online courts run by the judiciary and by different administrative tribunals, and in different countries they take different organizational forms. But the bottom line is that judicial procedures that are using online technologies of different sorts, I'll briefly review them shortly, are becoming very prevalent. And there's a famous site called odr.info, which concentrates a lot of the knowledge and sort of keeps track of what is going on in this field. And it lists at least 60 different courts world over that are operating an online dispute resolution program. The number is likely larger, but this is at least the documented instances. And more recently, and I've seen this was part of your program also yesterday, due to the social distancing instructions in really all countries, many courts have launched different forms of online dispute resolution, some of them just online hearings via video conference tools, others more elaborate case filing, case negotiation, case management, different ODR tools, not necessarily platforms. So I really think that this has been a tipping point, a turning point for this field, because much of the traditional resistance to the incorporation of online court proceedings that we've seen in many countries will likely now be reduced or changed or transformed in many ways, since really everyone needed to jump into the cold water and do more things online, including in courts. There is a project called remotecourts.org that is run by Richard Susskind, who is one of the really visionaries of ODR generally and of online court proceedings more particularly. And that site reports that there are at least 66 countries that are now using remote hearings and other online techniques just because of the coronavirus restrictions. Okay, so this is just a background to sort of make the point that this is a very relevant discussion to many court systems. I now just want to put on the screen my main messages for today, which are first, that online court interfaces represent a tension between user friendliness and user autonomy. And in many times, these two competing interests or design goals will compete with each other and will require us to really maneuver a nuanced design. And what is related to this is that the design of online courts is not just a usability issue, so to speak, but it's really a procedural justice issue and even a substantive justice issue, as I hope I will convince you today. Now, in order to set the stage for this argument, I want to first sort of level the playing field here and just give a brief background on ODR and online courts, and specifically the context of it, which is not just access to justice and self-represented litigants as is often considered, but also caseloads, costs, and a reconceptualization of what courts may be. And then I want to discuss the premise, which is human-centered design, and what is related to this premise. Talk a little bit about the literature on human decision-making, and particularly human decision-making in the context of digital choice architecture or digital choice environments, suggesting that online courts should be viewed as legal digital choice environments. And so much of what I will be saying today really is also relevant to legal self-help websites and any other legal services that are provided online. So it could be, Zoom or Rocket Lawyers or some of the commercial services that you are all probably familiar with, but really a much larger chunk of e-government initiatives and online legal initiatives. So in Israel, for example, my home country, the Ministry of Justice now lets citizens basically conduct a lot of legal actions through its websites, through a series of forms and tools. And so much of what I will be saying today also has to do with that. So it's a really larger scope of access to justice considerations. And then I'm going to ask, how can we leverage online court interfaces, or for that matter, any online legal interface, to improve access to justice, understood in a broader sense. So to start us off, I just want to quickly note what ODR is, to those of you who are not familiar with this term. So when I talk about online dispute resolution, I refer to systems that enable completing a full dispute resolution process. So not just particular tasks, but the full process, from filing through the formulation of an outcomes. Sometimes these systems also include an enforcement component, but all of it happens in an online environment. The fact of the matter is that this term is often used to describe very different services. It's now really an umbrella term that refers to a rich spectrum. We're talking about disputes that originate both online and offline. We're talking about negotiation processes, mediation, arbitration, judicial processes, jury processes, and even new models of resolving disputes. There is a very wide range of technologies that are being used, starting from basic forms and wizards, going through VC, and up to different models such as crowdsourcing decision-making, or using automation or learning systems in order to generate settlement proposals, as an example. And we can also see that there are a very varied set of process designs that are all falling under this umbrella term of ODR. So to focus us on what I'm talking about today, let me just point to this. So as we've seen now with the coronavirus, a lot of what people are talking about as ODR is simply just transposition. We're taking the traditional process, whether it's mediation or an online court hearing, and we're moving it to an online space. So it could be a virtual conference, it could be chat, it could be even just a holistic messaging system. It has benefits, of course. It's more accessible in terms of time and space. And there's research that suggests that it allows people to better manage their emotions and maybe neutralize some power dynamics. But there's no real innovation here other than just changing the medium of communication. Probably the most common form of ODR that we'll see, certainly within courts, has to do with restructuring the process, primarily in order to design it for lay users. So we're talking about taking the complex rules of civil procedure and simplifying them to support a very streamlined and simplified process, adding to the various phases of the process, whether they're in an online wizard or in structured forms, tailor legal aid, support information in order to make the decision, allow for case intake and evaluation, make sure that we use the interface in order to avoid procedural errors in terms of the jurisdiction, type of claim, and so forth. And really use an everyday language that is different from the language that we've known from the rules of civil procedure, as an example. Lastly, we have these other new models that I've mentioned earlier, ones that are relying on computation and on learning systems that generate predictions or propose different outcomes for the case, using social media tools, using crowdsourcing. These are sort of the novel developments in the area of ODR. Most of them, in fact, all of them have not come into fruition, or and they are far from being implemented in online court settings. But I imagine that some of the future lies in these systems. Naturally, we see a lot of hybrid processes that combine different elements of these models. We see tiny bit of automation in some courts, particularly with case diagnostics, but not as much in courts. What I'll be focusing today is really this bit of the process, the restructuring, the idea that we can take a fairly complex litigation process and transform it, restructure it, both in terms of the dispute resolution process and in terms of the user experience, what we are asking the users to do in order to complete the process, how we're presenting the process to them, how we're eliciting their actions. And I'm going to suggest that digital choice architecture has a huge impact on the promise of online courts and the ability of online courts to provide improved access to justice, to deliver just outcomes and ones that we would want the justice system to deliver. And this is really an instance of a term that some of you are more familiar with the field may have heard in the past. The role of technology as the fourth party in the process, the idea that other than the two litigating parties and the judge or the mediator that assists them in shaping a resolution for the case, the platform itself, the technology itself, has a strong impact on shaping how the process would follow and what outcomes will come out of it. And interestingly enough, I think that a lot of how much of the way that online courts are shaped today is actually due to sort of the evolution of ODR from really a service that was born in e-commerce settings in the context of e-commerce disputes, eBay really as the primary example. To those of you who are not familiar with this case, eBay early on has faced about 60 million disputes between buyers and sellers on the system. Most of them were fairly low value. There were, of course, huge issues about jurisdiction and the ability to use any of the traditional court procedures or even ADR, alternative dispute resolution procedures, to resolve these disputes. And there was a tension between the costs that resolving such a dispute would present and the need to develop trust of the users of the system to make it for a safe and trustworthy business environment. And so eBay really needed to design a process that would support a large bulk of disputes to be resolved by lay users. There were no lawyers involved. And to help really those users resolve these cases on their own, because it was really impossible to employ arbitrators or mediators or even customer service representatives to handle all of these disputes. And interestingly, and likely because this dispute resolution system that eBay has designed is today considered really the paradigmatic ODR system or the role model for most of the systems that evolved after it, we can see some of these intuitions, this notion that we need to handhold users, that we need to simplify the process, that we need to aspire to help the parties shape their own outcomes, reach a settlement, really essentially, are affecting the way that online courts have evolved world over. So in Canada, you're, of course, I'm sure all know the Civil Resolution Tribunal, which has been pioneer in designing online court proceedings. Similarly, now in England and Wales, really the entire civil justice system is going through a transformation with the design of the online solution court, which is migrating online all civil disputes up to £10,000 and in the future £25,000, and a host of other processes, including family disputes, tax disputes, and other cases, and spreading throughout the world through commercial companies such as Modria or Matterhorn that are selling really off-the-shelf platforms that are customized by different courts. And all of these systems have faced problems that in a way resemble or resonate some of the problems that eBay users have faced, but of course the scale is much bigger. So a lot of court systems world over are facing a large population of self-represented litigants that need to traverse the process without the help of a lawyer to mediate its complexity. Of course, there are litigation costs that are very high and act as a barrier for access to justice to many people. Many of these courts need to handle these challenges as they're facing large caseloads and very little staff. So eventually the duration of litigation is very long. There are general access issues, both in terms of the complexity of the law, but really just the physical space, getting to a court during business hours, taking a day off work in order to do it, and so forth. And these systems need to face these challenges with very limited resources, both in terms of court staff and legal aid. And I want to say a little bit more about this context because I think it's important to remember how this should shape the design of online courts. So first, with respect to the caseload crisis. So we're saying there are more cases, but there's similar number of judges, maybe even less judges, and of courtrooms, and generally resources for the systems. This is associated with increased settlements. So in many court systems, really in all court systems, I think the vast majority of civil cases settle, they're not adjudicated. And this is associated with a phenomenon that is called the vanishing trial, a term coined by Mark Galanter in 2004, suggesting that really just a fraction of the cases that go into court are eventually tried and determined in a judicial decision on the merits of the case. And this is associated with the development of managerial judges and with the idea that judges now do a lot in terms of just managing the interaction between the parties, but not necessarily determining the merit of the case, as I mentioned. Now, this is both a problem statement, but also a benchmark. And I think this is an important idea to remember, because on the one hand, online courts are now trying to provide a better service than what this model, the current traditional model, is proposing. And on the other hand, as we sort of examine the results of online court processes, or as we examine the type of justice that they deliver, we need to remember that this is sort of the benchmark that reality currently provides. And of course, I would say we want to aspire for more, but at least for the time being, we need to remember what we are comparing this to. The second bit of context is, again, the access to justice motivation and the potential. So as I mentioned earlier, many courts are facing large number of pro se litigants that represent themselves without lawyers. This happens in multiple case types, sometimes in ones that are very important for really the well-being of these people, such as housing cases. In some of these case types, there are up to 75% of the cases that involve self-represented litigants. And the problem, of course, is that when they are faced with a complex legal system, many of these cases are really dismissed right at the door of the court for failure to state a claim or for filing in the wrong jurisdiction and so forth. And there's also a problem of disengagement of these pro se litigants, or of non-engagement altogether. So oftentimes people would join the process or start the process, but then abandon it halfway through. And there is really a huge problem in many jurisdictions of defendants that never show up and then just get a default judgment issued against them without really resolving the case or on its merit. It's important to note that this is not just a problem of self-represented litigants. Generally, due to these obstacles that I've mentioned earlier, including the costs and the duration of proceedings, we are now talking about the efforts that courts need to take to improve court experiences altogether, to provide better sense of procedural justice to all those who come to court, and also to rethink or reimagine what service courts may provide to litigants as a whole. Possibly now thinking not just about courts as a place where we adjudicate claims, but as a place where we resolve problems, or where we offer citizens a way to get their life back on track. And I want to show, just as an example, using data from Israeli courts, what I'm referring to when I'm talking about the problem statement, the benchmark, and the potential. So looking for example on this data that is taken from a sample of Israeli magistrate courts. So this is the first instance of civil proceedings in Israel. This is where 95% of the civil litigation takes place in Israel. We can see here on the screen, and I'm using my mouse to indicate that, what type of role judges play in the process. So we can see sort of the vanishing trial in Israel here. So just about 11% of the cases actually go to trial. In the US, as an example, this is a much more severe problem. Just about 1 or 2% of cases reach trial. About 90% of the cases and during pretrial. This means that at least the litigants have met or seen a judge in the process. But in 70% of the cases, litigants never get a face-to-face interaction with the judge. And in about 40% of the cases, they don't get anything from a judge. So there's not even a decision on a motion or any sort of written interaction with the judge that affects or shapes the case. Now, when we cross-tabulate this data with how cases end, we can see that during these stages, which are not trial, yes, most of the cases settle. This is the yellow and orange colored bars here. And also, a lot of the cases are just abandoned or reflect a disengagement of litigants with the case. Now, I want to emphasize that these are figures that don't take into account small claims where parties are self-represented, and that in the vast majority of these cases, litigants were represented. So this is data from Israel. Nonetheless, we see that there's a huge problem of disengagement with courts or of non-engagement with courts. We see that about 20% of the cases altogether end in a default judgment. About 8% of the cases are abandoned by the plaintiffs themselves, and some of them are withdrawn in very early stages and without any decision by the judge, possibly suggesting also this sort of disengagement with the process. So really about a third of the cases represent, and this is again, not small claims, not self-represented litigants, are cases in which people still drop out of courts. And they drop out of courts without a settlement. So yeah, without any outcome that they helped shape. And my contention, and I'm sort of ending here my key setting the stage slides, is that you should remember that the potential of ODR and our potential of transforming litigants' engagement with the process transcends this idea of just minor disputes, just small claims, just self-represented litigants, but we're really talking about a larger portion of the cases. And that this transformation has to do with empowering people to make better decisions about how to end their disputes in these stages. Because it is only in those cases, and even not in all of them, that a judge would shape the outcome. So we are now talking about the potential to use technology, to use online courts, to provide for better experiences, for better outcome, for more procedural justice, for more substantive justice for nearly 90% of litigants in courts. Okay. So how do online courts aspire to do this? Well, in most online courts, and I'm using here at the process description that the CRT is boasting, but it's really a model for how a lot of other online courts that were later launched now exhibit. Well, litigants are first asked to diagnose their case. So they go through a series of really like an online questionnaire or a wizard in order to figure out what is the problem, how can they define it in legal terms, is filing a lawsuit the right solution for them, or should they exercise some other option, whether it's an ADR option, or really they can resolve their problem in a different way. They then file a case. This is really not shown here, but at this point they would file a case using an online form on the system. And they would then engage in a negotiation with the opposing party, possibly formulating a settlement on their own at this stage. If that fails, then they move to facilitation. This is really something between case management and mediation, where there's a representative of the court or the tribunal that helps the parties reach a settlement at this point. And if that doesn't happen, then they move to adjudication, which can take place based on the materials, the documents, the evidence that has been shared earlier in the process, or can involve also an online hearing or a face-to-face hearing, depending on really the circumstances and the discretion of the adjudicator and sort of the wish of the parties. We can see also, and I know that your group is really focused also on the role of automation, that there's some level of automation involved in these early phases, mainly decision trees that help parties diagnose cases, and some just auto corrections and very basic elements in the process. But it is certainly the aspiration of many courts, I think, to use this structured collection of data in order to offer in the future more advanced learning and more advanced data processing elements that would possibly help the parties reach better outcomes. I know that there are some providers that are currently working on operating just chatbots and on trying to use some basic NLP and machine learning in order to study the input that different that parties enter in the different phases of the case. But this is really still very early stage, very nascent. Okay, so let's summarize. The typical online court design uses some very basic premises that I think are common to many of them. First, it's designed with self-represented litigants in mind. And in doing that, at least they aspire, not all courts do this with great success, but they at least aspire to use a human-centered design approach. So I've referred here to a wonderful book and a website by Margaret Hagan, and if you don't know her work, I highly recommend it, from the Legal Design Lab at Stanford, talking about how legal procedures, not just online, really everywhere, can be redesigned with the users at the center. This echoes some of the other concepts, such as a procedure for the 99%, the idea that the legal system should not just be designed by lawyers and for lawyers, but for the citizens, for their primary users. And this is where the idea for simplified and streamlined procedures comes from. And this is also where the general design of online courts, which promises to handhold users through the process, to continuously orient them, to help them navigate the proceeding, to provide them with the necessary information that they need in order to complete the process, and to make sure that they remain engaged, that they don't drop out, that they don't abandon, or that they just initially come to discuss their debt and find some repayment plan rather than just get a default judgment, and which would later be executed. This is where it comes from. And I will briefly show you an example of an interface so you could see how this comes around. It is also a premise of most of these courts, and you could see it in the little diagram that I showed before from the Civil Resolution Tribunal, that the assumption of most of these courts is that users will shape their own outcomes with the help of the platform, possibly with the help of the facilitator, in a large majority of the cases. So the processes encourage information exchange, and they encourage independent problem solving, and they encourage settlement. The idea is that only in the small portion of the cases, in the UK, for example, they aspire for no more than 30% of the cases will actually reach an adjudicator. This is really a last resort and an idea of really turning the pyramid on its head, right? The process is designed for settlement. It's not designed for an adjudicatory decision. And of course, in the background, there is also the efficiency and the costs motivation. In many countries, the shift towards online courts was motivated by austerity policies, the need to cut costs. the idea that they really need to improve their clearance rates, so really deal more efficiently with the current docket rather than expand access to more users that would come into the system and get better access to justice. And we see this also in some of the design decisions of some courts. So just so you can have an idea of what I'm talking about, here's an example of how a person, a plaintiff, would file a money claim online in the new online solution courts in the UK. This is at the stage where they have not yet developed their equivalent of the Civil Resolution Tribunal Solution Explorer, so they don't have the triaging phase or the self-diagnosis phase yet. This is really when you're already making your money claim into court. So you can see how the interface design looks like. You can see how at the beginning of the process, there are several diagnostic questions that are meant to help the litigant figure out what information they need to provide and what process is relevant to them. And then really it's quite straightforward. There are very few phases. It is mainly form-based. There's not a lot of information on the screen, but the process is quite structured, right? So you indicate how much money you want and for what reasons. You can calculate interest for your claim. You can enter some basic free text information to explain why you think the money is owed or why you think that this claim is valid. And then the other party would get an email. They would enter the website. They would see a similar screen explaining to them how they may respond to the claim. They would then be shown a little option to select whether they admit the claim, part of the claim, or reject the claim. Then an opportunity to explain why they reject the claim, and then possibly make a settlement offer to the other party, provide some information about this offer, and then the plaintiff would see what the offer is like and would say yes or no to this offer. Following that stage, of course, there's the possibility of mediation and case management, and then finally adjudication by a judge if a settlement or other consensual solution is not reached. So this is how the process looks like. And this is where also my talk, or the substantive part of my talk and what's new about what I'm saying, begins. And I hope that we've sort of leveled the playing field and that you've now all gotten an idea of where ODR came from, the different motivations, both institutional and policy-wise, in terms of improving access to justice, but also managing the many suboptimal patterns of case processing within courts. And let's now talk about how this solution, the ones that I've shown you of the online solution courts in the UK, or the one that the CRT proposes, or any of the other services that I've shown on my first slide, well, what kind of challenge they are facing in their effort to provide a policy solution to all these varying problems using online tools. And as I mentioned, the key tension that I'm going to talk about is the tension between usability or accessibility, user-friendliness, engagement, and autonomy. The idea that courts need to provide people with self-determination, with a just solution, and really in processes that rely primarily as their really procedural model on decisions that the parties shape themselves, whether it is to settle or to withdraw the case, how to make sure that this decision is informed and deliberate and reflects their actual interest after they have considered the relevant information for making that decision. And importantly, how do we make sure that this process is as free as possible from bias? Because if you remember when I mentioned earlier that technology acts as a fourth party in the process, I fear and I have some concerns that in our race to provide more accessibility, more user friendliness, more streamlined processes, more structured, we are also introducing bias into the way people use the system, into the outcomes they get out of the system, and eventually, if they realize it, also to their sense of procedural justice, their trust in courts, and their long-term willingness to use this procedural option. So really, what I contend is that court interface design is not just a usability issue, but also a procedural justice and substantive justice issue. And to make sure that I have your that you leave this talk with what my main message is, here are my key takeaways before I dive into the detail. First of all, the court user interface inevitably shapes how users behave on this interface. Type of legal actions that they take, how they claim their rights, how they defend their rights. And this is particularly true when we talk about vulnerable SRLs, self-represented litigants, that are not experts in this domain. And the only way that we can make sure that courts do not introduce bias into this process is if we use evidence-based design. And I will suggest some ways in which we can do that. The other point is that if user interfaces are too user-friendly, with the hope that we make the process accessible, then we make the decisions that people take on these platforms less informed, less deliberate, and we risk really prompting them to make decisions that do not maximize or truly represent their interests. And a solution to this problem would be to introduce built-in friction into the design of online court processes, with the purpose, with the goal of improving the quality of decision-making, and we can talk about what that means. The third point is that to top these challenges, it turns out, based on really a very large body of research, that the impact of interface design on user behavior, on the trust that users feel towards the system, on the ability of users to make informed decisions, varies by demographic and situational attributes. So people of varying ages and of various cultural backgrounds, and sometimes gender, and really situational attributes such as the time of day or the device that you're using, suggest or operate differently on different users. So this opens the question of whether we should dynamically tailor the interface design of courts in order to make sure that we provide adequate access to justice and procedural justice to different classes of users. And it's also a way to rethink about how courts can be equally open and equally supportive of diverse litigant populations. So we can talk about a little bit more about that also in the discussion. This alludes also to a host of normative challenges, because naturally any idea of personalizing court procedures or court interfaces, I think immediately triggers some ethical concerns. So I'll suggest some responses to that, and possibly a distinction between shaping the environment and shaping the process itself. So how should we look at courts as digital choice environments? So there's a really large body of literature in behavioral economics, in social psychology, that suggests that there's no choice environment that is neutral. The way that we present different choices affect the actual choice that people would make. And we know that in a predictable fashion. So we can really know how to shape an environment in a way that would induce more people to make a particular choice that we intend them to make. In this way, people can be nudged both intentionally, if the choice architect is intentionally implemented in architecture, or unintentionally, if we design choice environment without even knowing that we are impacting users, to make certain decisions. Now, interestingly, in the past mostly 10, 15 years, there's research that shows that these same principles of behavioral economics, social psychology, also operate in predictable ways in online environments, this time adding to the different social psychology mechanisms such as anchoring and defaults and decoy effects, a host of other design elements, interface design elements that shape user behavior and experience. This domain is now termed digital nudging, and it has to do with really adjusting the visual attributes of the interface and organizing the workflow through which on a platform or on a process that you're completing online in order to influence users' input and decisions. So in consumer contexts, you can see it in different design features that are intended to make you, subscribe to the newsletter, spend more time on the website so that you are exposed to more advertisements, buy another product that is related. If you're presented with a product and it's noted that many other people have found this product useful when they buy your product, this is really an appeal that combines social psychology nudges with interface design, with digital nudges. Now, what's interesting about digital nudging, as opposed to nudging in the physical world, is that it operates in the point of decision making, because the entire workflow is done online on the interface, which is why research has shown that it has increased effectiveness. There's great success in influencing people's choices and behavior online. It's very cheap, it's very easy, it's very quick to introduce the digital nudge, and the effect is very easily measurable. So a lot of SaaS companies, online consumer platforms and so forth, routinely conduct A/B testing, right? So randomly assigning people to two different interface designs just to measure how that impacts their behavior. It's very easy to do, it's very readily available. So here's an example for how an anchoring effect would operate in an online interface. So let's say we have a little indicator, a slider indicator here. The literature on digital nudging and really the research would show that depending on where the bar is located as a starting point, people would make a different selection. So if the bar is located at a 0 or is located as at 50, the value that people would actually choose would change. Now, the premise of digital nudging, and the reason that we should be particularly concerned about it in the context of online courts, is that it then operates in conditions where human decision is already suffering from attention scarcity and selective attention, thus more prone to the effect of bias. And really, when people are making these fast and near automated decisions on an interface, they're more likely to neglect to look at relevant information or to disregard it. And they are eventually likely or more likely to make poor decisions compared to what they would make in an offline setting. And this effect is particularly heightened on smartphones. And I note that we now have statistics on how people use online courts. And we see that particularly with self-represented litigants, the majority of them are accessing online courts via smartphones or tablets. So this is not a hypothetical concern, it's really an actual concern. Now, the classic digital choice architecture tools or mechanisms are really just to use in a purposeful way radio buttons or checkboxes or drop-down menus, or even just something as simple as a text box. Examples would include to have a pre-selected default option, to introduce a decoy option, so an option that doesn't really mean anything, but its mere introduction influences the choice that people make. Ordering the options that people would select in different ways. So there's a primacy effect and a recency effect that operate in different ways. There's anchoring, which I mentioned earlier, and really just choice overload, right? If we introduce too many choices for people to select from, it confuses them and they don't necessarily select the most relevant option. This screenshot is taken from the Matterhorn ability to pay assessment. This is part of their online dispute resolution process that is implemented in several courts. Another important set of biases includes the display-induced bias. This has to do with the fact that when different visual attributes of the screen are manipulated, people can be induced to choose an option that is different from their stated preference just because of where it is located on the screen, or the amount of options that are presented on the screen, or even just the color or the font in which an option is presented. So I'm going to just briefly present some of these examples. So one example is a visual bias to the middle. This is a screenshot from the Civil Resolution Tribunal Solution Explorer, where we see different options to select, well, how you would characterize your disputes. Now, we have research from consumer contexts that suggests that by locating an option in the middle of the screen, if we have, say, a 3x3 matrix, or if we locate an option in a 4x4 matrix to the left, people are more likely to choose that option, even if it is not their stated preference. So just the location on the screen matters. This effect is perceived, particularly when people are made to make decisions fast. So while on online courts, this is not necessarily the case, the process is not paced. Remember that it is designed to make it easy for them and to make it streamlined. And so there's really a design that is inducing them to act more quickly. And I want to point here to the potential to actually use this in a positive way to draw people's attention to the more relevant information, or to organize information on a screen in a way that induces deliberation. And for example, we have research that suggests that people are much better at considering different options, especially when these options have multiple attributes. So imagine, for example, different settlement offers, or a procedural decision whether to withdraw a case with whatever that means in terms of procedure, or to settle a case with whatever that means in terms of procedure, so that people have all the relevant information, which may later impact whether they can refile the claim, whether they can appeal whatever has been decided, and so forth. So this is really also a way to leverage what we know about this field in order to improve the design of courts. Another display-induced bias has to do with fluent and disfluent fonts. Now, as you've seen in the examples that I've shown, really the vast majority of online courts use very fluent fonts, fonts that are easily readable, that are clear, that are fair size, usually dark colors. And this has to do with the idea that we're simplifying and we're making everything more readable and accessible. This is contrasted with disfluent fonts, which are not as easily readable, that they take longer to read because letters are not easily differentiated. It may be faint colored and so forth. And so you see here an example of different fonts, and you can decide for yourself which one is more fluent or disfluent. But what I want to suggest is that the choice of font is actually very important. And then sometimes choosing the easier, more easily readable, the fluent font is not the best option if what we want to do is improve the ability of people to process information and make deliberate decisions in the process. Recall again, most of the outcomes in online courts are shaped by users' own decisions. So it is actually these fluent fonts that have been shown, and there's different evidence, and some of it is mixed, to improve information retention, improve cognitive processing, increase the ability of people to reflect on what they're actually reading so that they can deliberately choose in an informed sort of choice what they're making. The main idea here is that we want to slow down people's decision making when they're making very important choices, so that we make sure that they consider all the relevant information. So here's just an example of that other screenshot that I've shown you before. And you can see here where it's very clear that the procedural options are in very fluent fonts. What they mean is shown in a lot less fluent fonts just because of the faint colors. And if you want to find out what each response means, you need to sort of find that in the much smaller text font. And I'm not sure it's been tested to see that people are actually not making their choices based on, or that people's choices are not influenced by the impact of the fluency of the fonts, or really even the order of the font, as we've mentioned earlier. I'll briefly, because I see the time, we'll skim through these last effects. So visual complexity and colorfulness, I'll just briefly say that the way information is presented on the screen, whether it's in an asymmetrical or symmetrical design, whether there are a lot of images versus text or vice versa, how many groups of text are on the website and so forth, influences how people feel about this website, how they're able to process the information. The same has to do with the colorfulness of the website, both the color scheme or the palette of colors that is chosen, the intensity of the colors, the diversity or the range of the colors that are used. All of these are have been shown to impact the way users react to the website. And this is very important because this first impression is very powerful, especially if we're talking about an institution, an online course that wants to make sure that people trust it and still ascribe legitimacy to it, still respect it, as we would want to have an online course in society. Interestingly enough, in this case too, age, gender, nationality, or cultural background are associated with different preferences. So it's also very difficult to choose just a single design that would operate similarly on litigants of all demographics. While this seems like a fairly intuitive assertion that, you know, the visual complexity or color scheme affects how users respond to the website, we can see different levels of complexity and of color schemes in different examples. So this is two different versions of the money claim online platform. You can see the varying color schemes and visual complexity of them. These are two examples for online sponsored small claim mediation. The different color scheme, one that is more warm and informal, one that is allegedly more formal. We can test how these actually impact the way users perceive and use and make decisions on the website. So let me bring this to conclusion because I'm mindful of the time. I think that in the design of online court interfaces, we need to create a better balance between user friendliness, usability, accessibility, and decision support. The idea that we need to support litigants' ability to make informed and deliberate decisions, to participate in a meaningful way that supports their self-determination and their autonomy, especially given the context that it's litigants' decisions and choices and inputs that shape the final outcomes on this platform in the vast majority of cases. And the way that I would suggest to do it is to introduce what I call built-in friction into their user experience. Leverage a design of the platform that is not as streamlined, fluent, easy, in order to make users passage through this process a little less effortless, a little less susceptible to bias, a little bit more engaged cognitively, mentally, so that they can deliberate and actually make intent decisions on the platform. Unfortunately, I've seen no research and even not questionnaires within the self-assessment matrices that courts use that measures whether their users actually understood the choices that they've made and their implication throughout the process. This would require a fairly rigorous research design. So what I would hope will happen in the future is that we would have evidence-based choice architecture within course. Since the premise is that there's no choice environment that is neutral, that is not necessarily, that is not necessary for a choice architecture to be deliberately manipulative in order for it to have an effect on litigants, we must seek to design interfaces that are actually promoting procedural and substantive justice through evidence-based, human-centered design. This would mean that we need to develop an empirical research strategy that is ideally based on randomized controlled trials, so courts that randomly assign litigants to different user interfaces and then measure how these impact their decisions on courts. There are some ethical concerns with that, which we can discuss later in the workshop, and there are some responses to why we should still do that. Otherwise, we can use just the ex post data analysis. So with every user interface update rollout, we can measure and see how the behavior in court processes has changed, how outcomes have changed. And we can just do online experiments. So before introducing different interface design features into the process, measure how they actually impact the behavior of users. I'll skip it, but I can return to it in the workshop, what kind of data we can capture in order to measure the impact on behavior. Regrettably, most online courts today use primarily self-report bias. We've had just a couple of studies that have used actual case docket data to measure the impact of courts, of online courts. So this is just a list of possible variables that we can use in order to measure behaviorally the impact on what users do. And because of what I've mentioned, the fact that user interface operates differently on different demographics, I think it is essential that we have demographic information of participants so that we can make sure that there isn't a particular population subgroup of litigants that is adversely affected by the courts, by the interface design of the court. And I'm sorry that I'm rushing through this. I'm really happy to come back to this in the discussion. But lastly, I think this opens the way, at least for a discussion, not necessarily a conclusion, about whether it is worthwhile to take this opportunity and think about personalizing court interfaces. Because if we know in predictable ways, for example, that female litigants are more likely to retain information and process it more deliberately when it's presented horizontally, whereas men are more likely to do the same when the information is presented vertically, then we can consider the option of presenting information differently based on gender, just as an example. This again raises a host of ethical and normative consideration, but just to sort of end the part where I'm presenting with a brief initial response to that. In the literature on nudging, and we can draw from that to digital nudging as well, there's a lot of writing about how nudges that are actually meant to impact system 2, to help us deliberate more effectively, and nudges that are meant to educate us or to help us navigate complex proceedings are more ethically acceptable, even if they're targeting different demographics. Okay, so I'm sorry that I had to sort of rush through the last bit of my presentation, But I thank you for this opportunity to present, and I'm really looking forward to the discussion and to hearing some of your thoughts on these issues. So thanks very much.